of Pittsburgh are rolling down that eastern seaboard.
Truer words were never spoken. The Schilling Show continues here on a Wild Wednesday edition. We go now to Byron Henry, a board-certified attorney and a constitutional scholar. Showdown over North Carolina bathroom law. This is the federal government stepping in and trying to step on states over the boundaries, in my opinion, of the United States Constitution. Let's find out what Byron Henry thinks. Hey, Byron, welcome to the Schilling Show. Thanks for joining us today.
Great to be with you.
All right, would you tell us about this North Carolina law? Because I'm concerned about the characterization of it by the Associated Press and others in the mainstream media. What exactly is this law?
Well, first of all, the law entails a lot of issues and a lot of items. The restroom part of it is a very small part of it, and so it has a lot of issues about what cities can do with respect to minimum wage, and can they pass their own laws that differ from state law and things like that. But what's in the news is a specific part of the law that simply says for government buildings and universities, that includes universities, of course, for public buildings and public restrooms at government buildings, that all of the government buildings and those officials in authority there are required to have a men's restroom and a women's restroom, and that the delineation of male and female, or for the men's restroom and the women's restroom, will be your biological gender as reflected on your birth certificate. So to cut through any issues of confusion or who goes where or whatnot, they just drew a line and said, equal for everyone, whatever's on your birth certificate, that's the restroom you use.
Okay, well,
pretty common sense it seems, but that's basically what the law says. It does not apply to private businesses, and in fact, there's no penalty. It doesn't say people are going to be taken to jail if they use the wrong restroom or anything, and I don't even think the law's been enforced yet, so there's been no harm yet. But that's basically the substance of it is men are men based on their birth certificate, women are women based on their birth certificate, and that's the restroom you have to use in public buildings.
Okay, does that also include shower facilities, for example, in a university?
Yes, it includes what are considered those intimate areas such as locker rooms, changing facilities, showers, or restrooms. That's correct.
Okay, so Byron Henry, it seems to me in years past, and when I grew up, you know, if there was a man that walked into the high school girls' shower who, for whatever reason, thought he was a woman that day, he probably would have been arrested. And so were there laws on the books previously, or was this just something that society observed without needing a law for it?
Well, that's a good question. There's really no law per se about certainly not private restrooms. And before House Bill 2, there was none regarding public government restrooms either in North Carolina. The way it usually works is, first of all, it's custom and tradition to observe certain things. One of them was the men use the men's restroom and women use the women's restroom. Of course, it's private property. So, you know, the store gives you a license to come in and follow the rules, so you don't go into employees-only areas. They can ask you to leave or issue a criminal trespass citation or call the police and have you removed from the building. So any enforcement that would have occurred would have probably been from repeat offenders that wouldn't follow the rules, were in places they shouldn't be in the store or in a business, and they'd ask the police to come out and just bar that person from the premises by issuing them a warning for criminal trespass. And that would normally, I think, still today be the way that a law or not a law, but a person's rights on property, a property owner's rights would be enforced, is through that kind of mechanism.
So now the United States Department of Justice has involved themselves here. What is their legal premise?
Well, their legal premise is one that is relatively new. I won't say completely novel because it's been floating around there for about the last 6 months, maybe even as long as a year, that the phrase in the Civil Rights Act, because of sex, which appears in a host of state and federal laws in every context, from education to employment and otherwise, that because of sex includes because of gender identity. In other words, the word sex includes gender identity. That would be relatively new. Most courts that have reviewed the statute that was, by the way, passed in 1964, I believe, or 1965, have said that it does not include things like sexual orientation or transgender status. Those are issues that would, or classifications that would need to be added to the statute through an amendment process through the legislature. But as it stands, the Obama administration's Justice Department has taken the position that we can make an argument that gender identity is included in the phrase because of sex, and as a result, passing this ordinance saying you have to use the restroom based on your biological gender as opposed to your I guess, emotional gender is discrimination, even though it's based on how you feel, not on what you are on your birth certificate. The Justice Department believes that that's close enough to gender-based discrimination to constitute a violation of federal law.
So I'm wondering where this ends, and we're talking, we got just a couple of minutes left with Byron Henry, a constitutional scholar, board-certified attorney. You know, beyond gender identity, racial identity, so if they're, you know, giving out scholarships based on race, can I just identify with that race? How about age identity? I want the senior discount, so I'm 66 today. Or health or disease identity. I believe I have cancer, and so I want certain benefits paid for me. Or even species identity. I'm a lion today, and I want to be able to go into the zoo and go into the lion cage. I mean, where do we draw the line?
That's a great question, because even though I'm in my mid-40s, there are many days I feel much, much older and think I do need special protection based on age. So with respect to identity, you asked the perfect question. We know we can test the person's race. We know we can test a person's age. We know we can test a person's gender. But if you open up because of sex, remember, the Civil Rights Act doesn't mention bathrooms. It just has because of race, religion, national origin, age, ancestry, and the whole litany of the list that we all learned when we were in school what the Civil Rights Act protects. So if gender identity is included in because of sex, then certainly you could make an argument, a logical argument, that racial identity is included in that definition as well. And so for the Attorney General to get up there and say this is like race discrimination is not only ironic, but it's certainly a little bit offensive to all those that fought for civil rights, because now what she's saying is if I identify as a minority or an African American, then I'm entitled to all of the protections and all of the benefits that the African American community fought so hard to achieve when they were trying to achieve equality and end segregation and whatnot, which is what the Civil Rights Act in its inception was all about.
So let's talk about the end game here, and we've got just about a little over a minute left, Byron. The end game here, North Carolina, how long can they hold out against the feds? And if they don't prevail, do they have any other option?
Well, first and foremost, it's a litigation, so it's basically they're saying that we're not going to cower to a letter from an executive office. We are going to wait and have a federal court tell us that we are somehow violating federal law. So you've got to play it through the legal process so they can tough it out through the entire legal process. But what's more interesting is I believe other states are going to get involved, because if the Justice Department takes this view of the Civil Rights Act, all of the other laws come into play, and basically every state and every locality that distinguishes between males and females based on biological gender, whether it's sports teams or showers or scholarships, as you mentioned, they're all breaking federal law according to the Department of Justice. And I would be shocked if other states don't get involved on the side of North Carolina in this litigation going forward.
It'll be fascinating to watch. Byron Henry, board-certified attorney and constitutional scholar, thank you so much for joining us today on The Schilling Show.
My pleasure.
I appreciate your analysis very much. All right, we go to the break and come back on the other side. It's a Wild Wednesday edition of The Schilling Show, and we will have...